Section 147 of the Constitution says there must be at least one minister who must be indigenous to each state of the Federation. Does that mean the President can only appoint 36 ministers and nothing less? Well, that's one question we will be answering on the program today. Welcome to this week's edition of Law Weekly on Channels Television. I'm Victoria Idowu. We will also be looking at if Nigeria really needs the ministers for its ministries to function properly. But before that, let's take some court stories. Now, Justice Adeni Ademola of the Federal High Court has reserved ruling in an application filed by the former Bayelsa State Governor, Mr. Timper Silva, to quash charges filed against him by the Economic and Financial Crimes Commission, EFCC. Now, counsel to the former governor told the court to set aside the charges against his client on the grounds that he cannot be rearranged on the charges that had already been dismissed by the same court. But the counsel to EFCC objected to the application, saying the new charges is different from the one dismissed by the court last month. He said the charge had been expanded to a 50-count charge from the initial 42 counts.
The immediate past governor of Adamawa State, Admiral Murtala Nyako, and the former governor of Imo State, Mr. Ikedi Hakim, have been dragged before a federal high court in Abuja, where they are being arraigned on alleged money laundering charges. Admiral Nyako is being arraigned on a 37-count charge. His son, Abdulaziz Nyako, is also being arraigned. The charges were preferred against them by the Economic and Financial Crimes Commission. On Friday, the former Imo State governor got lucky as the court granted him bail. Justice Adeni Ademola released him on bail on the condition that he provide one surety in the sum of 270 million naira. Meanwhile, in Kano, a former governor of Jigawa State, Sule Lamido, and his two sons, Aminu and Mustafa, did not get that lucky. They would be spending the next 2 months in prison custody. The former governor was arraigned alongside his children for allegedly receiving 1.35 billion naira kickback from a government contractor. The presiding judge, Justice Evelyn Anyadike, ruled that the 4 accused persons be remanded in the Kano prison custody because the EFCC said they lacked enough facilities to accommodate them. Earlier, the defense counsel, Mr. Effiong, had argued that remanding the accused persons in prison will amount to trampling on their fundamental human rights. The trial for the Lamidos is fixed for 28th of September for hearing. A correspondent in Kano says that the court was besieged by supporters of the former governor who chanted songs in his support. The police are reported to have fired tear gas canisters into the air after an altercation ensued between supporters of the former governor and the police. A federal high court sitting in Abuja has dismissed a fundamental human rights enforcement suit filed by an alleged mastermind of the April 14, 2014 bomb blast in Nyanya, a suburb of Abuja, Mr. Aminu Oguche. Mr. Oguche asked the court to order his release from the custody of the Department of State Service and award 600 million naira as damages in his favor for being kept in detention since his arrest in July of 2014 without arraignment before any court. The presiding judge, Justice Adeni Ademola, in his judgment, held that the suit lacked merit as the applicant's detention by the DSS since July 15, 2014, in order to complete its investigations, was backed by court orders. He also held that the orders made by the various courts allowing the accused detention for successive periods were in line with the powers the court could exercise under Section 27 of the Terrorism Prevention Act of 2013. He also ruled that the suspect, who had been kept in detention since his extradition from Sudan, where he allegedly escaped to after the bombing incident, had been subsequently arraigned on terrorism charges before Justice Ahmed Mohammed, also of the Federal High Court in Abuja. A coroner sitting in Ikeja, Lagos State has called for the investigation and possible prosecution of the two structural engineers who built the collapsed six-story building belonging to the Synagogue Church of All Nations, which killed 116 persons on September 12, 2014. Delivering the 47-page verdict, the Chief Magistrate, Komolafe Oyetade, reminded everyone that the coroner, which was merely a fact-finding body, was set up to look into the cause of death of 116 victims after a building at the Synagogue Church of All Nations collapsed. In a summary, the Chief Magistrate concluded that the death of victims was caused by a blunt force trauma sustained from the building collapse. Structural failure due to the combination of designs and detailing errors, the coroner also reveals that the alleged aircraft flying over the building had nothing to do with the collapse. Building permits were not obtained by the church in respect of the additional structure added to the building. Also, foundation failure is a remote cause of the collapsed building. He therefore recommended, among other measures, that the contractors, engineer Oladele Ogundeji and Akimbela Fatiregun of Hard Rock Construction, should be investigated and tried for criminal negligence. The church should be investigated and be proceeded against under the law by relevant authority for not possessing necessary building permit. CSP Haruna Alaba, the divisional police officer in Ikotun, should be transferred and replaced. The incident occurred on the 12th of September 2014 after a guest house located within the synagogue church premises around Ikotoegbe of Lagos State collapsed completely on the ground, leaving 116 people dead. A federal high court sitting in Port Harcourt has dissolved the 22 local government councils in the state. The presiding judge, Justice Lambo Akombi of the Federal High Court, in his ruling said the decision of the administration of former Governor Chibike Amechi to go ahead with the conduct of the council election on May 23rd in spite of a court order asking all parties to maintain a status quo as a flagrant abuse of court process and disregard for rule of law. The ruling comes as the Rivers State Command of the Nigeria Police says it has foiled an attempt by arsonists to raise the Federal High Court.